Good afternoon, as it now is, everybody. Welcome to Decker Chambers' latest webinar on police law. Roddy, Abbott and I will be doing a couple of presentations for you today. We expect to take about an hour. I'm going to be talking about common law duty of care in negligence, and Roddy will be talking about disciplinary law. There is, as usual in Zoom, a question and answer box at the top, Q&A, and a chat button. If you have any comments or questions, please feel free to leave those for us there, and we'll endeavour to answer them during the course of the webinar. If that doesn't prove possible for any reason, we'll get back to you, and we'll try after we've finished. But without further ado, I'll begin. So what I'm going to be talking about is, as I say, is duty of care and negligence and the importance of duty of care to claims against the police. As we all know, that there are a number of elements to a claim in negligence, and the first of those is what Clark and Tindall describes as the existence in law of a duty of care situation. And only once that's established does one then go on to consider whether that duty has been breached, whether there's a connection between the damage asserted and the careless conduct, and the question of whether the particular damage is too remote. So the importance, as far as we're concerned, really, on a practical basis, is that duty of care acts as a filter, and that defendants are not potentially liable to all claimants in the universe for all types of harm who might be suffered by a claimant. As one American judge once put it, liability for an indefinite time to an indefinite class of people, or words to that effect. It's a control mechanism to keep negligence liability within what are regarded by the courts as reasonable bounds. And practically speaking, this means that if somebody is clearly outside those reasonable bounds, we can apply to have the cases struck out as showing no cause of action. That means that you can avoid an expensive investigation into the facts through having to go through the processes of disclosure, inspection, witness statements, and so on, and indeed having a trial. So it's important to be aware when analysing where we are now of the historical position. We need to go back to the late 80s in the case of Hill against Chief Constable of Yorkshire. This was the Yorkshire Ripper case. The claimant was the mother of the last victim, and she complained that West Yorkshire police should have apprehended Peter Sutcliffe before he harmed her daughter. The House of Lords held no duty of care owed for two reasons. First of all, it was established that there was no duty owed to the general public to capture a known criminal, so it would not be logical, therefore, to say that they owed a duty to capture one whose identity wasn't known. And secondly, it was contrary to public policy to have a negligence claim because it would lead to a defensive mindset and the police being distracted from tackling crime. Hill was then applied in a number of further cases over the next 15 to 20 years. First of all, El Ghazouli Daf, where it was held that no duty was owed to detain suspects in relation to ongoing investigations. Two suspects were accused of serious crime, they said, on flimsy grounds, held no duty of care owed to progress and to investigate those crimes competently. Brooks, the claimant there, of course, was the friend of Stephen Lawrence, who was killed in a racist attack in South East London. And he complained of the police's, the way in which he'd been treated by police officers, but held, though he had other causes of action, which were not the subject of the strike application, he was owed no duty of care as a witness to that fatal attack. And then finally, in the Smith case, it was said that because the perpetrator was known to the complainant and was named and was known to the police, that would make all the difference, and the majority held not. Again, no duty owed. So, although now the public policy ground had been largely discredited in the reasoning of those subsequent decisions, the reasoning relating to the breadth of the duty and the lack of any particular feature giving rise to liability remained valid. But it was widely thought, therefore, that the police had a so-called immunity from claims in negligence. So where have we got to now? Well, the modern approach to be applied is set out in two decisions of the Supreme Court decided in the last decade. The first was Michael. The victim here made a 999 call received by a neighbouring police authority, complaining that she was scared of her former partner. And this was relayed to the home police authority, who graded the call as requiring a 60-minute response. The victim made a further 999 call to the local force and was heard to scream, and it was found that she had been murdered by her former partner. The estate and the family made claims under Article 2 and in negligence. The Article 2 claims allowed to proceed to trial, and I won't consider that further. We are concerned solely with the negligence claim. By a House of 7 held no duty of care was owed by a 5-2 majority. Lord Coulson gave the majority of judgment. He emphasised the distinction between, on the one hand, cases where the defendant caused injury to the claimant and cases where the defendant failed to protect a claimant from injury caused by a third party. The same rules, he said, applied to the police as to other defendants. There's no such thing as a special immunity for the police in relation to negligence claims. And this particular passage is very important. He points out that public bodies who have widespread statutory functions do not generally undertake responsibility to injured parties for the actions of third parties. It would be contrary to the ordinary principles of common law to impose such a burden. Further important findings. First of all, you can't say there's going to be a liability solely for domestic violence victims. It wouldn't be appropriate to create a liability only for particular types of incidents. It was suggested that the imposition of liability would improve the police response to domestic violence issues, and Lord Coulson said, well, there's just no way to know that. What we do know is that imposing liability would have substantial financial implications. Claimants argued, well, you should allow a claim in negligence because we've got an Article 2 claim as well, and it was held that that was not a reason to expand negligence liability artificially. And in conclusion, it was said the police have no liability in cases of pure omission by the police to perform their duties in the prevention of violence. This was then built on in the case of Robinson. Mrs. Robinson was an elderly lady who was knocked over in the street in the course of a struggle between police officers and a suspected drug dealer. She brought a claim in negligence for her injuries, and at trial, the recorder, the trial judge, held that the police were negligent in trying to arrest the suspect when there were members of the public in the vicinity. However, he said, as a matter of law, the police could not be sued for negligence. The case that Mrs. Robinson lost in the Court of Appeal, but the case found its way to the Supreme Court. And a number of important points. First of all, we all know from the universities the 3-part test in Caparo Industries and Dickman, something that we're taught about as taught law 101, really. But the Supreme Court pointed out that, contrary to what everybody seemed to assume, the existence of duty of care is not to be determined by applying that test in every case, but you start by looking at the previous case to see what they've decided. And then if it's not decided by those previous cases, you then go on to see whether incremental development would be appropriate to allow liability. And it's only if you have to consider a development of the law that public policy is relevant. And then it was confirmed that generally it would make no difference to liability whether the defendant's a public authority or a private individual. And the general principle is stated there at paragraph 33 of the judgment. Important to emphasise there the fact that statute may provide otherwise, for example, by authorising conduct in question. We'll return to that point at the end. But the point here was that it was actionable harm we were concerned with rather than an omission to protect from harm. establishing there, Hill does not establish a general immunity in respect of anything done in the course of investigating or preventing crime. So, moving on with the statement of general principle, no duty of care to prevent the occurrence of harm generally, but there are exceptions, and the Lord Reed referred to this extract from an academic article identifying 4 exceptions. Firstly, assumption of responsibility by the defendant. Secondly, preventing others from protecting the claimant. Thirdly, a special level of control over the danger. Or finally, the status of the defendant. In paragraph 70, a further statement of that principle there. Paragraph 72, it was pointed out that the police played no active part in the critical events in the Hill and Michael cases. It was held that Mrs. Robinson's claim was all about acts, not omissions. It was about the acts of the officers in deciding to arrest the suspect when she was in the vicinity and might be injured in the struggle. It was reasonably foreseeable that she might be injured, and the trial judge was entitled on the facts to find that the officers had been negligent. And the actions of the suspect in resisting arrest, it was held, did not break the chain of causation between the police's negligence and Mrs. Robinson's injuries. So that's the modern approach that the Supreme Court has required us to apply. So how is this actually being applied in practice? So I'm going to look at 4 cases. The first of those is Tindall. This is a decision of the Court of Appeal. It's about road traffic accident. A driver, not the claimant here, K, lost control on black ice on the road and crashed in the winter. He got out of his vehicle, and despite being injured himself, he began to flag down approaching vehicles to try to warn them, and while the emergency services were on their way. The police attended in due course and put up a police slow sign to try and warn approaching vehicles, and then removed the vehicle debris. Kay was taken to hospital because he himself had suffered injury, and the police then left the scene, taking their sign away. Rather inevitably, the claimant's husband came along, skidded on the ice, and sadly suffered a fatal accident. The pleaded case for the claimant had 2 elements. First of all, it was said that the police had made the situation worse by causing Kay to stop his attempts to warn approaching motorists. Secondly, it was suggested that the police had failed to protect the husband, having assumed responsibility to do so. And the master declined to strike out. And the case went straight to the Court of Appeal, and there's a useful statement of principle by the court, paragraph 54, which I'll set out in full and just summarise for you. First of all, powers to act don't of themselves give rise to a liability for damage. And so if the public authority has intervened ineffectually, so it's failed to confer a benefit on a member of the public, which would have been resulted if they'd acted competently, that will not be enough for a negligence claim. And even if it could be said that they'd taken control of the scene, such as the police took charge here of the accident scene, that won't be enough. So I just duplicate the slide there. Fourthly, knowledge of a danger which the public authority has power to address is not sufficient to give rise to a duty of care to address it effectually or to prevent harm arising from that danger. So merely knowing about a danger isn't enough either, or arriving on a scene of potential danger, even if the members of the public think that have an expectation there'll be an intervention. And the fact you've intervened and helped in the past is not sufficient to create liability. Right, so there is a slide missing there, for which apologies. We are going to make these slides available at the end. That slide is missing at the moment, so apologies for that. I will correct that in the final version. The chief constable went on to, the court went on to say that the police did not actually arguably require Kay to leave or misled him into leaving and ceasing his attempts to warn his motorist. He went to hospital because he was injured. So it simply wasn't realistic to suggest that in some way they had created the danger by their actions in relation to him. Putting up and removing the sign did not make matters worse. It merely restored matters to where they had been previously. And the power to control a scene does not create a duty of care. And so the transient and ineffective response of the police did not amount to an assumption of responsibility. Now, although this case was decided in 2022, it is understood that very belatedly, the claimant is now going to be trying to appeal to the Supreme Court. They're about 15 months out of time, we understand, at the time that they filed the request. I won't go into the reasons why that is, but it's possible that there may be a further attempt to challenge Tindall in the Supreme Court, but watch this space. So Magill, the next case I want to consider is a decision of the Court of Appeal of Northern Ireland from 2022. The plaintiff was participating in an Orange Order parade, and as usually seems to happen these days for such parades, protesters threw missiles. Police officers took shelter from the missiles, and further on down the line, the parade was halted for reasons which are not made clear from the judgment. That caused the plaintiff to be exposed to this ongoing attack. The police took no measures to halt it, and he was struck and injured by a missile. So it came before the Court of Appeal on a strikeout application, and in the amended pleading that was put before the Court of Appeal, two instances of positive conduct were alleged. First of all, that the police halted the parade, and secondly, that they positively prevented the parade from moving on. Otherwise, the allegations were ones of omission, such as failing to prevent the throwing of missiles and so on. Paragraph 19, the court categorises Tindall as a case purely involving omissions. And at 21, they said the exceptions that have been formulated to the cases where no duty of care will be owed are not comprehensive. So in other words, it leaves room for further exceptions to be enumerated. The court held that it was arguable the statement of claim did disclose a sufficient course of action. However, they didn't consider in the judgment the reasons why the police halted the parade. It's not clear whether those were made clear or whether they thought they were relevant, and in particular whether the police are authorised by legislation to control it. So certainly wasn't considered in the judgments at all. They did emphasise that that the successful resisting of the strikeout did not mean the plaintiff's claim would succeed. But nevertheless, it seems to me to be a fairly thin basis to hold that there was an arguable case there, if you consider properly what was decided in Michael and Robinson. Next case is the case of Holbeach, very recent decision of the master of the King's Bench Division in Northern Ireland. And the plaintiff here was injured in the Enniskillen in Remembrance Day bombing back in 1987. There are obviously limitation issues with the case, but that wasn't subject of consideration. The plaintiff's allegation was that was threefold, really. First of all, that the RUC had a plan in place to ensure the safety of the public on the day. They'd carried out searches of locations outside the parade, and they didn't search the particular location where the bomb was planted. The argument was for the plaintiff that where the police engaged in a pre-planned operation to protect the public, they assumed responsibility for the safety of the public. The master didn't accept that. What the police were trying to do was reduce an existing danger caused by the likely acts of third parties, namely terrorists. There was, he said, no distinction between the plaintiff and other members of the public attending the parade. There's a useful statement of principle in the judgment, which I'm going to call up on screen there, saying that when assumption of responsibility will apply, It is clear from previous decisions of the courts that where responsibility for a person's safety or the safety of their property has been assumed, three elements will usually be involved. Firstly, some form of engagement or relationship between the police and the plaintiff. Secondly, there will usually be communication between the police and the plaintiff. And thirdly, some form of assurance will usually be given by the police and the plaintiff, either expressly or implied. The master noted that there was no suggestion from the plaintiff that A, he knew of the security option, secondly, that the police communicated with him about it, or thirdly, that he was given any assurances, or fourthly, that he relied on the skills of the police in searching for explosives. The claim was therefore struck out because no arguable duty of care was owed. Again, that's just a surplus slide, the same principle again, sorry about that. The Woodcock case is the final one I want to look at. This is a very recent decision of Mr. Justice Ritchie, who was hearing an appeal from a decision of a circuit judge after a trial. So this was not a strikeout case. The claimant was attacked and seriously injured by her ex-partner on leaving home in the morning. And her case was based on two things. First of all, that they had failed to warn her that the partner was outside her house after a neighbour had reported his presence to the police that morning. And secondly, carrying out measures to protect her. So Mr. Justice Ritchie embarked on a detailed review of the case law, emphasising repeatedly that the authorities have recognised that there may be the exceptions to the general rule that police are not liable for omissions. It's important to note that he did not look at the Tafaris formulation, which I set out earlier when considering the Robinson case. He relied on general exceptions in principle that there may be exceptional cases, or there may be cases where it's an affront to liability. And he says that where there are exceptional special circumstances with greater duty to act, it would be there could be a duty of care. He says, I'm not setting out any wider principle. He said there's five matters in particular the court will have a look at. First of all, the foreseeability of harm and the seriousness of harm. Secondly, the known words and actions of the perpetrator. Thirdly, any course of dealing between the police and the victim and perpetrator. Fourthly, actions of the police in protecting the victim in the past, and finally, balance of public policy reasons. He says that if those factors are proven to exist with sufficient weight and severity and immediacy, only in such cases will there be an exceptional duty of care found. He says all cases in which the exceptions to Hill are asserted are utterly fact-specific, so I'm unable to construct any clearer guidance for myself and the authorities. He said then the duty of care turned on the events of the morning of the attack in light of the previous dealings. He carried out a detailed review of the background facts, including the dealings between the claimant, the police, and the former partner. And he looked at the five factors and said that the facts pointed to a duty of care existing. And there were, he said, therefore, special or exceptional circumstances that made it justifiable to decide the claimant was relying on the police to advise her of the perpetrator's presence, and that therefore there would be a duty of care. That decision is now under appeal. We understand that the police are attempting to appeal that decision. So, just a summary then of when you're faced with a claim for negligence against the police, how should you analyse it? Well, the first question to consider is the complainant complaining of an act or omission? And you must look at the substance of what the case is about rather than the way it's expressed, because obviously you could say that the reason a driver crashed into someone was because they were driving too fast, which is an act, or you could say that they failed to brake, which is an omission. But the substance of such a case would clearly be about the fact the driver was driving too fast. It could be considered consider the formulation in a case called then in Poole Borough Council, which concerned liabilities and social services, which is this formulation: distinction between causing harm, making matters worse, or failing to confer a benefit, not making matters better. And that, Lord Reed said, may be an easier way to consider the distinction. But there's not at the moment a rigid way or a clear formulation available for distinguishing between the two. So it's really about what the substance of the case is. Second question, were the police's authorised by statute? Now, this is quite clear that from Robinson, that if you are doing something that you're authorised by legislation to do, then you shouldn't be liable for it in tort. This hasn't yet been considered extensively in the case law, but it's hard to see how the police could be liable in negligence if they actually have the duty or power to do something. An obvious example is the use of reasonable force under section 117 of PACE. It would be inconsistent, certainly arguably, with that power to find that if the police use reasonable force, that they nevertheless breached a duty of care. This was not considered in Robinson at all. Not clear whether it certainly doesn't seem to have been raised before the courts as being a potential answer for the police. Would it be an answer, or does it only apply to the force used against the person detained? That's something the courts may have to consider in the future. And the third question, if it's an omission, if you decide that it's a case about omission, does one of the exceptions apply? Consider the Tafaris and Steele formulation set out in Robinson. Although it's only a first instance decision, I think the formulation in Holbeach is a helpful one in terms of assumption of responsibility. And I think Woodcock is perfectly wrong to suggest that the seriousness of the case and so on can actually make a difference. It's flatly contrary, in my view, to the proper understanding of Robinson and Michael in the Supreme Court. In terms of assumption of responsibility, there is a pending appeal to the Supreme Court in a case called HXA in Surrey County Council, and that's going to be heard in October. And that is likely to consider assumption of responsibility by public authorities having statutory functions in some detail. So that's my talk. Any questions, please pop them in the chat. And with that, I'm going to hand over to Ronnie.
Thank you very much, Paul. I'm going to attempt to share my screen now, and hopefully you can now see my slides. Perhaps if Paul could just confirm that those slides are up and visible.
I can see them, Rob. Yes, thank you.
That's fantastic. Thank you, Paul. Good afternoon, everybody. And I'm conscious that for those of you who are viewing this live, it's a nice sunny day outside, at least where I am, and that I'm probably the last thing between you and your lunch. So I'm going to go at a fair pace. Before I launch into my spiel, a little bit about my practice and why I'm talking on police misconduct. A fair amount of my practice involves civil claims against the police in a wide variety of contexts, but a fair amount and an increasing amount of my practice now involves police misconduct matters, and that is both acting for the appropriate authority. And for those who aren't familiar with police misconduct terminology, that is the prosecution, effectively, normally delegated to the professional standards departments of various forces. So I act for the appropriate authority of different forces, both in terms of advising on charges, drafting charges, and acting as an advocate when those matters come before a panel. But I also act as a legal advisor to chief constables who are chairing accelerated misconduct hearings, and that's an interesting angle and a little bit of variation to my usual practice, where one is of course acting for one party or another. So I see things from two different angles. I'm conscious that some of you may do a great deal of police misconduct work, so some of what I say may sound basic, but I hope even for those who do a lot of work, there'll be some interesting observations in there and some suggestions about where things might go in the future. Similarly, for those who practice predominantly in terms of civil claims against the police, I suggest that police misconduct being a growth area is something that is likely to give rise to further civil claims arising out of the same facts. And even if you don't deal with the police misconduct matters yourself, it's useful to have a general understanding of how police misconduct matters work and how they could potentially interact with civil claims. So with that preliminary introduction, the overview of my talk. So firstly, I'm going to look at the current environment and trends. Secondly, the basics of the misconduct regime, the distinction between accelerated and non-accelerated proceedings, zooming in on the so-called special conditions that are required for accelerated proceedings, looking at some recent challenges to excessively lenient decisions of panels, that's to say panels with a legally qualified chair, and also looking at some of the collateral challenges that have been brought against findings of panels with reference to disability discrimination. So, firstly, looking at the current environment, well, I'm sure I don't need to tell this audience that there is at the moment intense public scrutiny in the context of high-profile cases, of which Wayne Couzens is unfortunately only the most serious of a number of reported cases, and that's fed into a desire on the part of senior officers to act swiftly to stamp down on misconduct and root it out, and political and public pressure on them to do so. There have been a number of public statements, though, from senior officers across a number of forces that the current disciplinary regime is not fit for purpose, either because it's too slow and they can't get rid of officers who they would like to sack, or that decisions are being made too leniently by people who are appointed under the regulations to make those decisions, and they'd rather take the decisions themselves. The upshot of that is that it's a growth area. The number of cases brought will increase as resources are targeted towards investigating and prosecuting them, and that will in turn, in many cases, filter through into increasing civil litigation, because where misconduct results in a victim, often that victim will look to bring a claim. So just a couple of examples of how this has filtered into public discourse. This is an article from The Guardian, which refers to the Met Commissioner saying that it's crazy that he can't sack toxic officers who have broken the law. Here are a couple of quotes from the Commissioner that appear in that article. We've had some very worrying cases with officers who've committed criminality whilst police officers, and yet I'm not allowed to sack them. It's crazy. And we've got some officers who we sacked, but other legal bodies, he doesn't say exactly who, have the power to reinstate them, have done so. So I've got officers who we determine shouldn't be police officers, and yet I have to keep them. It sounds bizarre. I'm the Commissioner, but I can't decide who my workforce is. So palpable frustration there on the part of the Commissioner. This from The Spectator. You can see the headline there, and you may also be able to see at the bottom the opening paragraph, which says, this week the charity Crime Stoppers has set up a hotline for people to report corruption and abuse by police officers. Again, this filters into my point that cases are going to increase because now people are being actively encouraged to bring forward complaints and allegations of misconduct. Quote from that article in The Spectator: Baroness Casey's report, published in October, helps explain why the Met struggles to sack officers with a history of poor behaviour. It found that allegations were dealt with individually, so repeated or escalating misconduct wasn't spotted, the threshold for gross misconduct set too high, and the Met's professional standard units were under-resourced and inadequately trained. It goes on, some of the issues are capable of being addressed. The Met set up a 100-strong new team to identify rogue officers, but other flaws go to the heart of the misconduct system. And those flaws, it goes on to suggest, are that the reforms in 2015-16 made an already overly formal process even more legalistic, with hearings resemble court cases. Analysis by the Casey Review found that allegations made by the Met officers and staff against their colleagues were taking longer to resolve, 13 months on average, 20% 2 years or more, and that's causing huge frustration. There is also some emerging, though far from definitive evidence, that a legally qualified chair is less likely to dismiss an officer than a police chief was. But it does, in fairness, recognise at the end of the article that police officers are different. They are servants of the Crown, not subject to employment laws, but it must be possible, the author suggests, to devise a speedier and simpler mechanism for handling misconduct cases so that abusive officers are barred from policing for life. Well, saying it may be possible is easy, actually doing so is harder. So what do I think, based on my experience that I've outlined, about the current state of affairs? Well, frustrations are, of course, understandable. The public expects police officers to uphold high standards and expects those who don't to be rooted out. However, merely expressing frustration without analysing properly the reasons for delays or unexpected outcomes is not especially helpful. Police officers do have a unique status as office holders, and there is a difference between the consequences of disciplinary action for them and disciplinary action for, say, an employee in the public sector. If you're sacked from a run-of-the-mill job in the private sector, you're not barred for life from doing that job again. So the consequences for police officers of disciplinary action are significantly greater in many respects. Delays do occur, of course, but then delays occur in virtually all types of litigation where there's a substantive dispute of fact, and that's true across the board: civil litigation, criminal litigation, and indeed employment litigation in employment tribunals. Proving things is hard, and it's difficult to do so in a fair process. Furthermore, some aspects of the delays are not actually caused by the disciplinary process. Very often, where there are concurrent criminal proceedings, the delay is caused by the criminal proceedings and the desire not to complete the disciplinary process before the criminal proceedings, and therefore risk potentially compromising the criminal proceedings themselves. And of course, there have been significant delays recently in terms of criminal proceedings caused by COVID and the resulting backlog. Furthermore, lenient decisions can be challenged. So if there is dissatisfaction with decisions, then there is recourse to the courts to overturn them. And finally, I suggest there are other aspects of the regime, in addition to delay and leniency, which could very well be reformed. It would be helpful if they were. Moving on, these are the basics of the misconduct regime. Those who do a lot of work will know this pat, but for those who don't, here's an overview. So what I'm going to say applies to Home Office forces, non-territorial forces. British Transport Police, Civil Nuclear Constabulary have a very similar regime with only some very minor tweaks specific to their unique operations. The statutory power is Section 50 of the 96 Act, and the Home Secretary has issued the conduct regulations. The latest ones are dated 2020. Under that power, and those regulations set out standards of professional behaviour that are expected of police officers, the process for investigation, how panels are made up who hear misconduct hearings, what the outcomes are, and outcomes in this context means sanctions or punishments effectively, where appeals go, and also deals with accelerated misconduct hearings, which I'll look at in a bit more detail shortly. So standards of professional behaviour are exactly really what you would expect of police officers. There they are. I won't go through them in any detail. I would suggest that there's perhaps an increasing emphasis on the last one these days: challenging and reporting improper conduct. It's not enough these days for officers to put the blind eye to the telescope, as it were. They have to be active in assisting the process of rooting out misconduct. So those are the standards which, if breached, constitute misconduct. Who decides these? Well, the panels who are chaired by legally qualified chairs arise out of Regulation 28. So for non-accelerated hearings, this is, and those are made up in most cases of a legally qualified chair, police officer, superintendent or above, and a further lay member. Legally qualified chairs are a relatively recent innovation. There was the reference in that article in The Spectator to them coming in 2015-16. And there's the regulations that brought them in. Somewhat ironically, perhaps, given that they're now being criticised by senior officers, they were brought in to increase the degree of independence and perhaps reduce the perception that this was a closed shop and that police officers might be reluctant to sack other police officers. The trend, it seems now, is it's suggested going the other way, and they're also brought in to ensure that outcomes were legally robust and therefore would stand up to scrutiny, including appellate scrutiny or judicial review. What about the accelerated procedure? Surely, if the desire is to get misconduct proceedings done quickly, this must be something that it can be used to achieve that end. Well, that's part 5 of the regulations, standard misconduct proceeding, non-acceleration in part 4. In contrast to a panel with a legally qualified chair, the hearing is usually conducted by the chief constable, or in certain cases, another very senior officer. The appropriate authority, that's the prosecution, as I said earlier, can appoint a person to advise the chief constable under Regulation 8.6. So that's what I do when I'm a legal advisor, effectively acting a bit like a clerk to the magistrates. I'm astonished that any forces attempt to conduct these proceedings without a legal advisor. That's very foolhardy. There are very tight procedural timescales under the accelerated procedure. The hearing is 10 to 15 working days after the authority certifies the special conditions are satisfied. We'll look at what they are very shortly. The officer must respond within 7 working days. There's no oral evidence. Now, looking at that, you may think, well, here's a very fast procedure for getting to the end of the process. How come this isn't achieving the expedited justice that senior officers want? We'll come on to reasons for that in due course. If the chief constable finds gross misconduct, they have the same powers as a panel if they find gross misconduct in terms of sanction. If gross misconduct isn't found proved, then it can still be remitted back for a non-accelerated Part 4 procedure to consider whether it's mere misconduct, i.e. not gross misconduct. So that's the accelerated procedure in a nutshell. The special conditions, which I referred to earlier, have to be satisfied before the proceedings can be conducted under the accelerated procedure. So that's very important. The special conditions are in Reg 49.2, and they are that there's sufficient evidence in the form of written statements or other documents to establish on the balance of probabilities that the conduct of the officer concerned constitutes gross misconduct, and B, it's in the public interest for the officer to cease to be a member of the police force or special constable without delay. One might well ask, well, in what circumstances would it not be in the public interest for that to occur if paragraph A is satisfied? Certainly, those will be very rare cases indeed, I suggest. What does sufficient evidence mean? Well, there's some statutory guidance to gloss that, and you've got the reference to the guidance there. And that the accelerated procedure is designed to deal with cases where the evidence is incontrovertible in the form of statements, documents, or other material like CCTV, and is therefore sufficient without further evidence to prove gross misconduct, and it's in the public interest for the officer to cease to be a member of the police force. So incontrovertible is an important word there. There's a very helpful authority which looks at this test in more detail. It's Gannon. It's under Judge Pelling QC. It's under the previous regulations from 2008, but the differences are immaterial for these purposes. And what Judge Pelling said in Gannon was that it's plainly necessary for a disciplinary hearing to be fair, and fairness requires that there be a hearing in which the officer has an opportunity to question witnesses where he disputes factual allegations. However, doing that, which involves a Part 4 hearing, is by its nature time-consuming and expensive. Unnecessary delay in the disposal of proceedings is not in the public interest, and therefore the regulations attempt to balance the need for fairness with the public interest in speedy disposal. An accelerated procedure was created in order to provide a cheaper and quicker alternative where fairness could be achieved without the need for a Part 4 hearing. So when could that be the case? He went on, where the material facts alleged to constitute gross misconduct are either admitted or are incapable of realistic dispute, then the focus of any hearing should be on whether those amount to gross misconduct and any vindication. It's only in relation to a case where there is no realistic dispute as to the facts alleged, or there's no realistic dispute as to any factual evidence relevant to whether those facts constitute gross misconduct, that the Part 5 accelerated procedure will be fair. So although it's always a little bit hazardous to import tests from one jurisdiction into another, this is, as most practitioners will recognise, pretty similar to the summary judgment procedure within the civil procedure rules, where one's looking at whether something is incapable of realistic dispute. Judge Pelling referred to the Home Office guidance because there was a dispute before him as to whether the word sufficient, which is in the regulation, is really the same as incontrovertible in Home Office guidance, and whether the Home Office guidance was going too far in saying that the evidence needed to be incontrovertible. Judge Pelling said there wasn't actually any material difference. And this is important to paragraph 7 in terms of which cases are suitable for the accelerated procedure. He said that the evidence would be unlikely to be incontrovertible where there was a factual dispute between witnesses, because the person conducting the hearing cannot rationally prefer one witness's evidence over another's without hearing them, save in circumstances where the evidence is inherently incredible or is inconsistent with other evidence which is incapable of credible challenge, such as CCTV or contemporary documentation. And that approach has been approved since by Justice Burnett, as then was in Evans, and by the Court of Appeal in Gray. So that is very much the current state of the law in terms of the test. It's important to note that although the appropriate authority certifies that the special conditions are satisfied and serves that certificate on the officer concerned, there's an obligation to consider whether they're satisfied up to the start of the hearing, because of course it might be that the allegations on paper look incontrovertible, but then the officer says, but hang on, I've got 3 witnesses who I can call on who will dispute them, and then it's no longer incontrovertible. So it's not just decided once and for all, it's a dynamic process that needs to be constantly reviewed. One oddity in Gannon and Evans is that they both proceeded on the basis that the person conducting the accelerated hearing, usually the chief constable, had the power to decide whether the special conditions were satisfied, and the officer could apply to them for a ruling as to whether they were satisfied or not, and if they weren't, apply for the matter to be remitted to the non-accelerated procedure. Well, that's wrong. I suspect that the reason that error crept in is because the phrase appropriate authority has, as it were, twin meaning in the regulations. But be that as it may, the regulations simply don't confer that power on the chair of an accelerated misconduct hearing. The decision as to whether the special conditions are satisfied is taken by the authority, which in this case, this means the prosecution. And the authority's decision is amenable to judicial review, but that's a very clumsy mechanism. I suggest it would be preferable that the person conducting the hearing did have the power, which the judges in Gannon and Evans thought that person had, with a possible appeal to the Police Appeals Tribunal in the event of challenge. A lot of the cases that I encounter, particularly as a legal advisor, are cases where the officer is saying, I dispute that the special conditions are satisfied. I suggest that there is not incontrovertible evidence, and there is no satisfactory procedure whereby that dispute can be resolved. And I think it's something that sooner or later it is going to be litigated further. And if the regulations are revised, that's one area which I think would be very suitable for revision. What about challenges to panel decisions? What if a decision is too lenient? Well, a very recent decision from the High Court suggests that judges will be sympathetic to challenges where they're well-founded. The facts of this case, which involved a British Transport Police officer, where the officer approached a lone female pedestrian whilst off duty, talked to her without her wanting him to do so, showed his warrant card to prove he was a police officer, made some remarks about her physique, showed her photographs of him working out, asked for her telephone number and a hug, and then later that evening addressed her as Babe in a text message. The panel, with a legally qualified chair, did find that the officer had committed gross misconduct as a result, but issued him with a final written warning rather than dismissing him, which is what the appropriate authority was asking it to do. And the Chief Constable challenged that decision in the High Court on the grounds that the decision of the panel was irrational, i.e. one that no reasonable panel could have come to, and also that it had failed to properly follow the structured approach to disciplinary outcomes set out in the guidance which is published for that purpose. And the High Court accepted those submissions. It found that the panel had paid lip service effectively to the guidance. It had referred to it, but it hadn't really applied it. And furthermore, that if it was applied correctly, the only reasonable outcome was dismissal. Given those facts, given the Cousins case, given the misuse of the warrant card, and the approach to a lone female, unsolicited sexual remarks, hardly surprising, I suggest, that the High Court did come to this conclusion, and very surprising that the panel did not. The judiciary as a whole is alive to recent developments and recent public concern, and the judge in this case made some interesting overture comments in that he specifically agreed with the Chief Constable's observations that these proceedings captured a real and present national concern about police officers' conduct towards lone women, and that the correct approach to outcome involved a consideration of wider factors, including the central importance of upholding public confidence in the police. And this was not a case which was an overreaction to other crimes involving other officers. This was part of wider public concern. So that's interesting, and I suspect that case will get cited to panels in the future with a view to, as it were, stiffening their sinews if they're wavering in terms of sanction. So an important case there. What about challenges by the officer to panels' decisions? Well, another recent decision in Eckland identifies what I consider to be a highly unsatisfactory state of affairs as the law currently stands. In this case, the claimant was a former officer, gave false evidence in court. There's no dispute about that. And as a result, he was dismissed following a misconduct hearing. He said that at the material time, i.e. when he was giving evidence in court and during the misconduct proceedings, he was suffering from a mental health condition, and that was a disability within the meaning of the Equality Act, and that it was that disability which had caused him to give false evidence. He brought proceedings against the Chief Constable under the Equality Act, alleging that his dismissal and the panel's failure to make reasonable adjustments as part of the misconduct proceedings were discriminatory, and that the Chief Constable was legally responsible for the acts and omissions of the panel. The Chief Constable objected, and as a preliminary point, suggested that they had no legal responsibility for the panel. The Employment Tribunal and the Employment Appeal Tribunal disagreed and rejected that point, and the Court of Appeal also rejected that point, and it applied the Supreme Court's decision in P and the Met. And P was a case which was about the implementation of EU equal treatment law, in particular a recent directive, and whether that had been implemented by Section 42 of the Equality Act. And as the Supreme Court interpreted Section 42, it said that it had been. And the court held in a similar case to Eckland that the principle of judicial immunity didn't prevent an officer subject to a decision of a panel from bringing a claim under the Equality Act alleging that the decision was discriminatory. Now one can see the problems here, that this is effectively a means of, or raises the possibility of a collateral attack on the panel's decision. So in front of the panel, an officer says, I committed this act because of a disability, and the panel says, well, we hear the evidence, but we reject that evidence, and we find that whatever your disability was, you're nonetheless you've nonetheless committed misconduct, and then the officer's dismissed, and the officer then attacks that decision as part of an employment tribunal proceedings alleging discriminatory conduct. Surprising, perhaps, in those circumstances, that the Supreme Court felt that in order to properly give effect to the EU directive, that should be allowed. And Lord Hughes expressed a degree of discomfort with that and hinted at possible reform. He said there exists a considerable potential for parallel or collateral proceedings in an employment tribunal and the police appeals tribunal, and that whilst this was in the present state of the legislation unavoidable, it might, however, usefully be considered in the event of any review of the overall structure. And I suggest that this is one of the points that is ripe for review. It is, in my view, ludicrous to have a quasi-judicial process with a route of appeal in which an officer can raise issues of disability to the extent that they're relevant to the alleged misconduct, and have findings made on that and appealed in relation to that, and then have them challenged in an entirely different jurisdiction. That is not a satisfactory state of affairs. If there are points that need to be made and can validly be made by the officer, those should be raised and dealt with as part of the misconduct proceedings. And so I think it's unsatisfactory, and perhaps now that the jurisdiction, the relationship of this jurisdiction vis-a-vis the EU has changed, that might give the government the grounds to change that and legislate to prevent that happening in future cases. So that's another point to look out for in terms of future developments. So to draw my conclusions in the light of what I've said today, police misconduct is a growth area, and it's likely to lead to further civil claims as well. There's pressure to speed up the process and to challenge lenient outcomes. And there's been public expressions from senior officers doubting legally qualified chairs, and perhaps suggesting they should be done away with. I don't think they will, particularly because whilst there is scope to reduce delays, there is already a summary disposal procedure, the accelerated procedure that we looked at, which is actually quite effective where the case is genuinely amenable to be disposed of summarily. But where there are substantive disputes of fact, it is simply inherent in proving those the facts that is a lengthy process if it's to be fair. And we shouldn't be surprised that it's a lengthy process across other jurisdictions and in other contexts. However, I think there could be amendment to the regulations to allow a better filtration process in terms of which cases are suitable to be subject to the accelerated procedure and which are not, and if there's a dispute about that, for that to be dealt with within the proceedings themselves and not to be subject to judicial review, as is now, I suggest, the correct route of challenge as the law currently stands. And one has to be realistic where there are substantive disputes of fact about how much more quickly those can be resolved. Lenient decisions, if they're perceived to be excessively lenient, can be challenged and should be challenged. And you will often find a sympathetic tribunal if you do challenge them. And the current state of the law, I suggest, which permits the collateral challenges on the grounds of discrimination, is seriously unsatisfactory. And as part of any reform of the process, that is one of the first things that should be reformed. That's everything from me. I think that's bang on 1 o'clock. I hope it's proved useful. If you have any further questions, please do ask in the chat or email me afterwards. I'll hand over to Paul just to wrap up.
Thank you very much indeed, Roddy. I don't think we've got any questions in the chat. So we'll leave it there and let you get to your soup and sandwiches or whatever your particular preference is this lunchtime. We will be making these presentations available. I've corrected the errors in my presentation, for which apologies. So that will be made available to all of you, as will Roddy's. Thank you very much indeed for your participation today, and we hope very much that our talks have been useful. Please do not hesitate to contact either of us if you have any questions about presentations or indeed your own cases, which we may be able to help with. We obviously cover the full range of police law between us, and we will look forward, we'd be very pleased to assist you. Thank you very much, everybody.
Thank you. Good afternoon.